good afternoon, everyone. My name is Tim Richards. I'm the Technical Services Manager of the Managing General Agents Association. And on behalf of the MGAA, I'd like to welcome you to our briefing this afternoon. This is being delivered by DAC Beechcroft on the subject of the Claims Lifecycle. Before I introduce our presenter, I'd just like to run through a few housekeeping points. Firstly, please ensure your microphone and camera are turned off. If you'd like to ask a question, feel free to use the chat button at the bottom of your screen. Time allowing, these will be asked and answered at the end of the event. And I was just speaking to Andrew, and if you want to send them through any questions through at any time, if I find a suitable break, I'll answer them during the presentation as well. So feel free to send your questions through on the chat facility at any time. If we run out of time, questions will be asked and answered after the event. And this presentation is accredited for CPD points if relevant to your ongoing professional development programme. The briefing is being recorded, and a link to the recording will be issued post-event together with the slides and our feedback survey. Please take the time to complete the survey, which will take no longer than 2 minutes. This allows us to deliver the best possible future events to our membership. So today's briefing is on the subject of the Claims Lifecycle from DAC Beechcroft. So let me introduce you to our presenter, Andrew Thompson. Andrew specialises in defending fraudulent motor claims in the insurance sector where fraud and/or dishonesty is alleged. He has particular expertise in the Gibraltar market, where he advises clients on all aspects of their claims function, and the wider motor market in Gibraltar. Andrew has over 14 years' experience advising clients on strategic and emerging fraud issues and the defence of fraudulent claims. He has interest and experience on advising clients in the emerging insurtech market in both Gibraltar and the UK. So without further ado, enjoy the briefing, everyone, and Andrew, over to you.
Thank you very much, Tim. Good afternoon, everyone. Thank you very much for the introduction. We can skip on that slide because Tim has zipped through and given you an outline of me and my background. So what I'm going to do today is talk about the claims life cycle from beginning to end, and where we want to get to at the end of the session is to describe how a claim looks from first notification of loss to conclusion, look at some of the opportunities and challenges around claims handling, summarize some of the challenges and issues within the court system, where I spend most of my time, and outline ultimately what influences a claims life cycle. So just to kick things off, the starting point of the claims process realistically is first notification of loss, or FNOL. Now, I've spent enough time over the years, as I'm sure many of you have on the call, listening to FNOL calls of policyholders reporting accidents. In the world that I live in around fraud, we are trying to work out whether they are telling the truth, whether the accident even occurred, what they're even talking about. But over the course of the years, with technology, things have moved on slightly. So now we're seeing perhaps less phone calls and more electronic notification of loss. So we are seeing claims notified to insurers and MGAs through internet portals, mobile apps, and even chatbots. Now, there's also telematics starting to come into play. I mean, telematics has been around for quite a while, but it enables an insurer to have a trigger automatically when a claim comes in. So what I wanted to do was just kick things off by breaking down what I think are the 4 accepted stages of a claim, so we can start there and then move through. So disclosure of the claim, I think that's when the claim is reported or notified. Inquiry. Now, there are multiple models around claims handling in relation to inquiry, depending on how a body is set up. There may be an in-house claims team, there may be a TPA function, there may be a outsource arrangement, but inquiry is very much the second layer of the claim before you reach determination, and then of course settlement and closure. So I think, although it's quite simple, that takes you in a nice neat 4-stage process from where the claim starts and where it ultimately ends. Now, in the world I live in, around personal injury claims, these have got a little bit more detail on, so I'll just touch on this so you can sort of see how perhaps an injury claim looks slightly different to a property damage claim or any other type of claim. and you go in stages. You work out who is responsible, you gather the evidence, you assess injuries, arrange medical care or rehab, review recovery, assess quantum, reach settlement, receive payment. Now, that realistically fits over quite nicely over the 4 stages that we talked about in the last slide, but that's very specific to a personal injury claim. Now, if you take that as a nice little bundle, onto the next step, I just want to spend a bit of time talking about the opportunities around the ability to impact a claims lifecycle. Now, I've put technology at number 1. When you see the next slide, you'll also see that technology is also a challenge, but technology is moving at quite a pace. There is a good argument that 70% of a claims process could or should be automated. Now, there are various arguments going back and forth about things like AI, for example. Now, AI is quite useful in the claims world because if you're looking at validation of a claim, AI can step in and lift items from a number plate, for example. So from open book searches, you've got the ability to speed up investigations into a claim by lifting certain information around MOTs, mileage, tax status from a registration plate. So there's a clear opportunity around how AI can plug itself into the claims process, automation, and ultimately speed things up. Now, robot process automation, that can validate at FNOL, but it can also present a challenge. Now, I'll probably talk about that now because it seems like a good time to do it. So in an AI-based investigation, for example, you are very much dependent on the code and the code being up to date and correct. Now, a challenge around a liability decision, for example, you may rely on AI to make a liability decision. You may well notify the other party that your insured is at fault, but the code hasn't updated to a very recent piece of legislation or case law, which actually would have impacted the ability to make that decision around the claim. So it could be that in relying on what's generated around the AI process, you in fact admit liability when you perhaps shouldn't have done. So there are challenges. It's not perfect, but it's certainly a developing opportunity to streamline and automate the claims process, which of course, in my view, will have a direct knock-on in relation to life cycles. Now, ADR mediation arbitration, the courts are very keen for parties to avoid litigation where possible. If ultimately you can't determine a claim and court proceedings are issued, there is a push into ADR mediation. A lot of time in the complex injury world, you'll have roundtable meetings with a view to trying to settle the claim before costs increase and life cycles increase. Now, in the small claims track, for example, there's a compulsory small claims track mediation scheme. It can have its pitfalls. Not everybody wants to engage in ADR or mediation, but the courts are very clear that if you don't engage in mediation when you perhaps should have done or you were given the opportunity to, you can be penalized in costs. Now, if you end up digging your heels in on a case and it goes on for a prolonged period of time, what you end up saving on damages, you can end up paying to the other side in costs. So for me, ADR, mediation and arbitration is a part of what we do day to day in the world of litigation. And in fact, it comes in pre-issue. There is nothing to stop parties having a discussion either on a formal or informal basis before proceedings are issued. So I think it's very much something to keep in mind. And ultimately, if it takes you to a place where you settle the claim quickly and promptly and economically, then it reduces life cycles and ends up reducing money that's held against a reserve, for example. So I think that's quite a key opportunity around how you can reduce them. The third point, of course, know your opponent work. Whether you're on the claimant or defendant side, I think it's fairly accepted now that you will be looking at who you are litigating against, who is on the other side. We have a KYO product where we effectively look at who comes up on the other side of cases. We can look at what strategies they adopt to either prolong a case or tactics that they might put in there to layer costs, for example, layer damages. All this stuff fits into the ability to make better informed decisions. It doesn't do your job for you, but for example, if you're on the fence about whether to pay a claim from a company that perhaps you were unsure about, the fact that you can go there and validate that against some data and information that's on a system enables you to make a better decision. And ultimately, if you move the case towards resolution, then that again has an impact on life cycles. So I'll touch on use of data analytics to reduce life cycles and indemnity spend in the next few slides. But I think ultimately what we're always trying to do is identify early red flags so you can accurately reserve cases and perhaps understand a little bit more about how the case looks. Now, in the world of chronic pain, for example, the identification of red flags is crucial to how you set your strategy, because you can have a case that on the face of it looks quite narrow and fairly low in quantum, but there are red flags on there around presentation of the claim, the injuries, the experts they're instructing, the fact that the claim may sit there for 12 months and before you know it, it's come back and the individual's now developed fibromyalgia or any number of conditions that will have a noticeable impact on both the quantum and how long you can realistically expect that case to go on for, because that case is not what it looked like when you first looked at it. So identification of red flags for me is a real opportunity around life cycle and indemnity spend. I'll touch on data, tracking market trends later, and also I'll look at benchmarking against the market, because again, if you can't see it, you can't fix it. And I'll just finish off there with basically setting a clear litigation strategy. Now, I've called it a litigation strategy, but I think you could call it a case strategy. Ultimately, when you have a case that comes to you, setting a clear strategy from day one will enable you to understand where you want to get the case to. I think sometimes where you come unstuck in any type of case is perhaps not setting an early strategy. And it doesn't have to be rigid, but ultimately, if you have a clear plan from the off, you're not reactive, you're proactive, so you can look at driving the case towards a resolution that you want rather than being dictated to by other factors. So I've put here some challenges. Now, I would say for the purposes of balance, I've put their claimant behavior. I very much sit on the defendant side of the fence, but I would freely admit that both claimants and defendants can have an impact on the life cycle of a case. Technology, as I said earlier, that can be a challenge. It can be a challenge for the reason that I sort of gave earlier, which was quite specific, but also you can have systems that don't fit how you run your business. You can try and plug in pieces of technology that don't necessarily deliver what you want them to deliver, and it can be quite difficult to get the best value from that technology if it doesn't necessarily suit what you need it for. New legislation. Now, the whiplash reforms are a good example of this. They have been a challenge on all sides. Again, there is a lot on both sides of the fence around the process and the system, but I would consider that's a good example of something that is a challenge around life cycles, because it's new, and anything that's new will take time to perhaps bed in. Systems, we've just seen the DCP come in and new online portals. As lawyers, we have to adapt to systems that are in place, but they can be a challenge, and they will be a challenge for us. They will also be a challenge for a TPA. There will also be a challenge for a claims team or a handler dealing with a claim first up, because naturally things that are new can be quite difficult to deal with. I think there's probably a view that some lawyers like living in the old-fashioned world of lovely big bundles and lots of paper. We don't live in that world so much anymore. Judges are more used to e-bundles. You know, the days of going down to the RCJ and seeing the carousel going around of numerous trial bundles, I think, have probably gone, and lawyers that don't necessarily adapt, and it goes for insurers as well, will be left somewhat behind. So new systems are a challenge. They take time to bed in. They can have an impact on life cycles. Claims inflation. Now, this is pretty much tied in with economic impact. Over lunchtime, we've just seen the interest rates go up again. So that's a key item on the agenda. Now, of course, this is all connected in that the longer a claim is on your books, the more susceptible you are to claims inflation. Now, there's been a recent review of the JC guidelines of life expectancy and Ogden tables. The discount rates up for review in 2024. Care costs. All of these things are quite specific to claims. But then again, you have plenty of factors that are playing into general claims inflation, such as price inflation, wage inflation, energy cost, supply chain challenges, construction costs. All of these things play into claims becoming potentially more expensive the longer they are on your book and the longer that they play into a life cycle. So this strategy that you have to deal with a claims life cycle from cradle to grave is very much impacted by factors that are perhaps outside of your control. And the final point there, just on delay, I think it goes without saying that the longer a claim is on your books, it has an obvious impact on your reserving. So just moving on to the next chunk around use of data and tracking trends. See, the statistics that I'm just going to talk about are lifted from our MI database. They're completely vanilla, so there's nothing in there that will come as any surprise, or I hope you won't be able to guess who we're talking about. But realistically, analytics and benchmarking allows you to compare yourself to the market. Now, the point I made earlier about if you don't see a problem or an issue, you can't fix it. Now, what you can do around analytics and benchmarking is lay your data against the market book, other insurers, other MGAs, and just understand a little bit more about whether you do have an issue, whether you have an issue that potentially needs to be fixed. So I'll touch on that. I'll also look at claimant behavior, and then I'll just wrap that up by sort of development of tailor-made strategies. Now, I don't propose to go over these slides in any great detail. They're in the pack. They'll come out to you after the presentation. There's probably enough in these slides to spend an entire lunchtime talking about trends and numbers and how these track. But what I've done is looked at employer's liability, public liability, motor injury, motor property, property liability, and disease. Now, these are all litigated cases. We would have the ability to lift non-litigated cases, but I wanted to just pull together a short bundle of stats, if you like, just to sort of paint a picture of how we can look at life cycles and how they track. Now, I've taken these from 2020 to 2022, and I think they're quite interesting because they show some things that will get pulled into the later stage of the presentation around the court system. Now, there have been some reductions in life cycles. See, public liability and employment liability, employer's liability are fairly similar. But if you compare those to some of the motor injury slides, which I'll bring up later, they are tracking completely the other way. So just on motor injury litigated, you can see on the £500,000 plus claim, the line's going up. Now, that suggests to me that the higher value cases are, one, taking longer to settle, but they could be stuck. Now, the one thing I would caveat is that will be a smaller sample. There will be fewer £500,000 cases on our books compared to, let's call them fast track cases, 25 to 100. But you can see the line is going in a direction that you would perhaps as a compensating party not want it to be, because since 2020 you've jumped from 934 days to 1,234. Now, that presents a challenge because that money is tied up. It has to be reserved and it can't be released until the claim's settled. Now, what you do see in some of these stats is anomalies. Now, if you look at the motor property litigated graph, and I think this is the point that I was trying to get to around looking at data and trying to understand what it tells you. If you look at the black line, which is 100 to 500,000, it dips from 2020 down to 2021, and then it spikes again in 2022. Now, I don't have the answer as to why that has done what it's done. It could have been a number of reasons. It could have been an influx of cases. It could have been a batch of cases that were settled quite quickly. Never rule out the impact of COVID and how that's played through into some of these graphs and charts, primarily because when COVID arrived almost 3 years, well, when lockdown came in almost 3 years ago to the day, not that I want to take you back to those lovely days in March 2020, the court system effectively shut down. Now, that is still coming back through the court system. Now, I think it's fairly clear that the impact of COVID on the smaller value claims was far less than the impact on the higher value cases because the courts couldn't hear them. The ability to get a judge, counsel, witnesses, experts all together for potentially a virtual hearing was problematic, to say the least. Now, some parties took the view that actually we'll leave that alone for a couple of years because we don't want to prejudice our case because of what's going through the court, and we don't want a remote hearing, for example. So I think these figures are useful in that you can look at things on bars and graphs and try and understand what they may tell you around where life cycles are going. Now, when I come onto the court study later in the session, I think you'll see that realistically the courts are struggling and numbers are only going one way, which is increasing. So just tying up here around property liability litigated and disease litigated, again, you can see some fairly clear lines. Lines have gone down, lines have gone up. But I think the picture that I want to paint around these graphs is that it's a snapshot of data that enables you to lay your information against, understand a little bit about which claims are pushing the wrong way, which claims are going in the right direction, and ultimately what behaviors and going back to the opportunities and challenges, what's impacting these life cycles, because as I say, if you don't understand them, you can't necessarily fix the issue that you're presented with. So those slides are there. As I say, I don't propose to go into the numbers. If there's anything that jumps at anybody throughout the webinar or afterwards, after you've taken a look at them, feel free to get in touch. Now, this slide for me is the interesting one. Now, I live in a world where I'm on the defendant side. I'm always looking at what my opponents are doing, because if I'm not doing that, I'm not doing the best job by my client. Now, these are merely a snapshot. Now, if you look at the 100 to 500,000 pound claim, firm X are going completely against both the market and firm Y. Now, we know who they are, and we are able to set a strategy around dragging that back in. Now, it's a worrying trend if say, for example, anecdotally, we say, well, this claimant or defendant firm are starting to be a bit of a pain. What you can do is you can extract the data from the MI and have a look at evidencing the trend. Now, on both of those graphs, the 100 to 500 and the 500 plus, the red line is tracking above. I mean, the black line, firm Y, is going back the other way. Now, that also helps you because you may well be able to understand that a reducing line may show, for example, an appetite to bulk settle cases. So it's not until you dig into that data that you can have a look at the behaviors around a particular firm or a particular credit hire company or a particular supplier. All of this gets laid on top of the know your opponent stuff, and it enables you to effectively make better informed decisions and potentially impact your life cycles, because there's an opportunity to have a look at what your opponents are doing. And whilst we do this on the defendant side, it's also done the other way around. So claimant firms are likely to have a look at MGAs, insurers, compensators, just to understand their behaviours, because ultimately the data is there to try and impact what your decision making is. So that slide's quite an interesting one. Keep an eye on FirmX. So realistically, tying this all together, what we do at DACB is we look at identifying red flags, tracking market patterns. We basically give our clients valuable insight into claimants, settlements, tactical considerations, but this is all with a view to bringing down life cycles, disbursements and defence costs. I mean, ultimately, we all want to avoid unnecessary litigation, so that enables you to move on into other cases. So tracking your performance against the market, this is all done via a tool that we have called Compass. We use it very much on the large loss side. Effectively enables our clients to model how those decisions should be made. So all this data that's sitting there gets pulled together and is layered over the top of our decision making and our clients' decision making. So that brings to an end that little section. I mean, now if you're talking about challenges, you can't escape the news over the last 12, 18 months, probably after COVID, but it was there anyway. Ultimately, the court system is creaking. Now, ultimately, if you can't settle a case, a claim is litigated. Now, the court system is very well established. When I qualified, I think I qualified just after the Wolf reforms, and I grew up with the White Book and the civil procedure rules. But I think before my time, it was probably a bit more fast and loose. It's very structured now. You'll see most barristers walking off to court with their well post-it noted White Book, and that's the rules that we all live and breathe by. The criminal court also comes into play, certainly in using motor as an example. If one of your insureds unfortunately was involved in a fatality, then there may be an inquest, and that definitely has an impact on how the civil claim comes. So whilst predominantly we live in the civil world, the criminal court also comes into play. It's prevalent in health and safety work, private prosecutions, although they're fairly rare and they're more of an enforcement point. But realistically, we live in a world of the criminal and civil courts. Now, the statistics that I've pulled onto a couple of slides are published in the House of Commons Library on an annual basis. It's an open source. You can find them, you can look at them, and the court statistics are reported for each type of court. Now, whilst I don't expect you to remember what this slide looks like, this is effectively a model case. Now, it's relevant because when I go on to talk about where we are now, Practice Direction 28 sets down a timetable for a standard fast-track case. Now, they say from allocation to trial, a fast-track case, and this goes across all types of work, injury, property, anything you like. They say that a case over £10,000 up to £25,000 should reach trial from allocation in 30 weeks. Now, taking into account issuing the claim to getting to that stage where you get directions is about 10 weeks. Keep that figure in your mind, because when we go on to some of these figures now, you'll see the jump between how long a case should take and how long a case is taking. Now, the most recent civil justice stats to December 2022, these came out this month. Headline points: county court claims were down, damages claims were down. Interestingly, the number of claims defended decreased, but the number of trials increased. Now, I think that's probably as a result of the court system gearing itself back up. The court system is not the quickest. Now, if you're talking about the throughput from COVID, I reckon only now are you probably starting to see some of these cases come back to life, because they've either been stayed, they've been adjourned, they've been new directions have been set. But more trials equals more judicial time, more court resources, and also delay. So if you talk about the mean time from small claims trials was 51.3 weeks. I think the killer stats on the next box, which is the meantime, and it takes into account multi-track and fast track, but there's a massive difference, 78.7 weeks. So if you took the decision that you were not going to pay a case and it has to go to trial because it has to be determined at trial, the average time for that case to reach a judge is 78.7 weeks, which has a huge impact on life cycles. And if you compare those figures to where they were, they've increased. I think the time a case reaches trial, I think that's quite a good measure of life cycles. So there were 13,000 trials from October to December 2022, which was up 3%. 76% of those were small claims. Now, I said earlier that small claims cases were impacted less by COVID-19. I think that's primarily because of their complexity. But against that, a lot of those litigants are in person. So during lockdown, I would guess that they were highly reluctant to come to well, I mean, some of them couldn't go to a court because they were closed, but the ability to attend a trial became quite difficult. Now, the other knock-on is as well that as lawyers, and I'm sure insurers as well, we've got far more used to living in a remote world. Lawyers had to adapt pretty quickly to virtual hearings, cloud platforms, and they have challenges. I can certainly give a couple of anecdotes of cases that I've come across in the fraud world where judges have observed notes being passed to witnesses. If you want my personal opinion on virtual trials around fraud claims, I think it's a no, because there's nothing more pressurized than being in a courtroom. And also as well, when you're accusing somebody of dishonesty, I think there's a better forum for determining things over a screen. But all of these things tied into delay. COVID-19 gave an inevitable uptick in the time that claims took to reach trial. And just some of the comment around those stats, they're quite narrow because they were in the build up to the Christmas period. So the decrease in the final quarter was probably likely to be due to Christmas. I think what you probably have to do is look at the bigger picture annual study rather than the sort of the more short-term stats. Interestingly, injury claims have fallen with general decreases. Now, I think that's probably in part due to the whiplash reforms, but they're still working their way through the system. Volumes across most civil actions have stabilized when compared to 2021. Now, I think the stats will probably tell you that it's probably too early to draw any real insight into the impact of COVID. Cases are up and running again. I'm seeing more virtual hearings, but it's not necessarily a given that you will get a virtual hearing any quicker than a physical hearing, because you still need a judge. So I think whilst technology has moved on and given an opportunity for cases to move, you still need judicial resources. Just some specific areas of concern here. This is a bit of a general slide. County courts are still struggling. You will have seen the publicity around the criminal justice system and the decline in funding. There've been quite public strikes from the Bar Council, and they are generally supported across the profession. There's probably less interest in the decline in the civil justice system. I think it's probably happened out of sight. I think there's probably a bit of difference between courts where people's liberty is determined as against people where money's just been passed from A to B. I think ultimately the headline points around the lack of funding in the criminal courts is far more headline newsworthy, and in my view, quite right too. But Central London County Court, slight anecdote there, but probably most litigators and anybody that's had any cases there will understand that's a black hole. Cases can go into Central London County Court and quite frankly disappear, never to be seen again. I think that's just because of the nature of the court itself. It's an extremely busy court and it's probably under-resourced. But if you look at that figure there, 394 days for a CCMC. Now, the CCMC is the first hearing where you basically set the timetable for the entire claim. So if you're waiting 394 days to even get directions, there's not, well, I say there's not a lot you can do. There are things you can do to move a case forward, but you certainly don't have any judicial directions, or basically from a litigator's point, you have no teeth. Because if you come across a firm of solicitors that are not willing to play ball, they will say, well, there's no direction for disclosure, there's no direction for expert evidence, we're just going to sit back. Now that's very frustrating, but it's unfortunately a challenge that we have. So when you compare courts in Yorkshire and the Humber, they're considered good performers, still 236 days. So this is a bit of an old stat just at the end, but it just showed the problems that COVID caused. 6,000 items of unanswered correspondence in Birmingham County Court, probably about 6 months into COVID. And Manchester County Court was taking 10 weeks to respond to correspondence. Now, if you talk about a life cycle on the hotline to Central London County Court, I think the last time I spoke to them, I was number 96 in the queue. But I had no choice to hold because I had a trial in 2 days, so I needed to speak to somebody. So that gives you an example of how challenging the court system can be. And just on the end there, 70 courts closed since 2010. Now, that hasn't received much publicity outside the legal world because it just doesn't. But courts have closed, and ultimately that puts far more pressure on the courts that are up and running. So I'll just touch on here, lockdown. The system functioned, but many trials were adjourned. During COVID, there was a listing priority system work that had to be done against work that should be done. I suspect that some courts have taken some things that they thought worked from COVID around priority. Certainly family proceedings and proceedings involving children took priority over, unfortunately, insurance-based disputes. Video hearings became more commonplace. I've already sort of expressed my opinion on the suitability of remote hearings where allegations of dishonesty, for example, are made. There was a lot of publicity around Nightingale courts. They never really took off. I don't know many people here that ever went to one. I've spoken to a number of barristers, and I don't get the impression that those Nightingale courts ever really went very far. There was some talk of judges sitting on Saturday, which you can imagine caused all sorts of grumblings. But again, I can't remember a case that was determined on a weekend. Ultimately, there's been some increased judicial intervention and case management. But as lawyers and certainly insurers, everybody had to become more tech savvy. E-bundles became the norm. We became a master of PDF docs. And ultimately, certainly in the insurance world, you would see more judges sat there on iPads looking at vehicle damage. Now, that, in my view, is far more appealing than sort of flapping around trying to find an order text report of a damaged vehicle. Again, I think there are some things that change for the better. Now, you take it back to the opportunities and challenges. That in itself is an opportunity to have more clarity around what judges are seeing and what lawyers are presenting to them, because ultimately the case needs to be determined, and the earlier and the more efficiently the case is determined suits everybody. But I mean, just sort of wrapping this section up around the future, ultimately I think delays are here to stay. That will have an impact on life cycles. The civil justice system is unlikely to attract significant funding or investment. Now, I think litigation has never been a quick fix. I think that's a given. The whiplash reforms, I think that's just starting to come through for those that live in the motor injury world. But ultimately, my view is that you can use timetabling to your example. When I talked earlier about a good litigation strategy, if you set your strategy well and early, you can use timetabling, for example, to your advantage. I'll use one example of a case. Last week, we are trying to instruct a neurologist to examine a claimant, and the CCMC was last week. The earliest appointment with a neurologist that we want to instruct is May 2024. Now, realistically, his report is not going to be available until August. So we put that in our directions. Now, I was concerned about that because a judge could quite reasonably say, well, hang on a minute, here we have a claimant that gets nowhere to a trial until 2026, but it got put through because we said, well, that's where we are. But you can use the timetabling to your advantage to effectively push things through, push things across, put pressure back on the other party. I mean, realistically, getting investigations done and making decisions early will have a huge impact on the life cycle of a claim. You know, my view on claims in the fraud world, whilst you might not always know, you will have a good idea, and this is what you lean on your expertise for. If it's fraudulent, defend it. If it's a genuine claim, attack it and pay it. Because if you get your decisions made early, you release resources, you free up reserves, you free up all the time pressure around delay. But ultimately, you put the pressure back on the other side. And there will be some cases that you cannot settle early. And you will have to be prepared to play the long game. Against that, there's an opportunity there to say to a claimant, well, look, we are making you an offer now. If this offer isn't accepted, you must be prepared for 3 years of litigation, and that could involve determinations, that could involve examinations, application hearings, court attendances. So all of these things, all these levers that you can pull will have a real bearing on how a claims life cycle plays out. So just bringing this all back to a nice, neat conclusion. Ultimately, what influences a claim life cycle? Realistically, the type and nature of the claim, whether that's a motor claim, whether it's a property claim, whether it's a very high value piece of insurance work, the type and nature of the claim will have a significant impact on a claims life cycle. The framework of the claim and how it's determined, now that goes back to pre-issue handling, how it's handled in your process, where it ends up, if it's litigated, where it works its way through. Does it end up in the court system? Does it end up in arbitration? Does it end up in a tribunal? All of these things will have quite a significant impact on a life cycle. Data and technology has a crucial part to play, both from a benchmarking point of view, but also from the ability to investigate and interrogate a claim, going back to the sort of the early slide around AI and the ability to impact a decision by the use of analytics or robotic AI or process technology. That fits quite neatly into operations and process. Each insurer or MGA or party will have a different setup, and that will depend on a number of factors. It will depend on size, it will depend on resource, it will depend on an in-source or an outsource model. So all of these things will have an impact on a claims life cycle. Cost, I think that covers all aspects, and also that pulls into operations and life and process rather, and technology, because the ability to develop technology requires investment. So I think cost can be taken into account on both the claim side, how much that claim costs you to settle, and also how much resource you have to invest in systems, operations, and processes. So it brings us quite neatly back into conflicting interests around resolution. You know, I can sit here with my defendant hat on, and I can say, well, I can look at how claimants behave, but there is an obvious tension in some cases. Now, I must say, not all cases. Certainly in the higher value catastrophic loss cases, there is probably a slightly different approach towards how you want to bring a claim from intimation to conclusion. It's a very different approach to, you know, I think I'm dealing with an entirely contrived accident. There's no cooperation there. You know, in the fraud world, it's probably a little bit more litigious and adversarial than perhaps it is around a catastrophic loss claim, which ultimately all parties want to bring to a swift and proper conclusion. So all of these things sort of take us into the influence around the claims life cycle, but I can just bring it back to hopefully meeting the learning objectives around describing how a claim looks from FNOL to conclusion, some of the opportunities and challenges, certainly the challenges around the court system, and ultimately that previous slide just sets out what we think influences the life cycle. So that is a whistle-stop tour of life cycles.
Great, thanks very much, Andrew. If you have any questions, anyone, feel free to put them through on the chat facility now, and I'll read them out to Andrew. I do have a couple of questions already.
Yep.
So the first one, Andrew, is before lawyers or a TPA become involved in the claim, what steps can an insurer take to mitigate any impact on life cycles?
Good one. Realistically, I think preservation of evidence is key. Now, a lot of that will depend on platforms, how it's kept, but ultimately, if you're investigating a case in the early stages, the more you're able to preserve and gather. You know, as lawyers, we like to live in the perfect world where we're given a nice, neat bundle of documents. A case may have litigated because the parties couldn't reach an agreement, but what we like to look at is a lovely, nice, neat bundle, and it doesn't always happen, of evidence, documents, images, reports, all of these things that were gathered together to sort of, you know, shape the decision-making process. So we can almost look at them fresh, reevaluate some of them, work out what arguments can work, what arguments can't work. But I think from a lawyer's point of view, I would always like to see, again, perfect world, nice evidential packages with everything there for us to kind of, you know, step in and move it along.
Thanks. And I've just had a question through on the chat facility, which is, may I ask how you view the last mile of the claims journey, the claims payout process impacting the overall life cycle? Have you identified any specific areas of opportunity or improvement within this part of the process?
Yeah, that's an interesting one, and perhaps it's the thing that gets neglected, because once it's done, it's done. You know, from our point of view, I think automation has to play a part in that area. The one scary story that I would bring to the table is around how do I say it? Well, basically the ability to intercept payments. Now, we've all heard horror stories about details being changed and payments where you think you're directing them to a claimant have ended up in a fraudster's bank account. It's happened to people that I know in the market. So for me, I think automation plays a key point, but ultimately a process whereby you are absolutely certain in the world that we live in, where most payments are made electronically, that you are making a payment to who is the intended recipient. Because, as I say, the last thing that I want is to be on the phone to our governance and risk team to say, unfortunately, we've just made a payment to somebody on the sanctions list. It's not a place you ever want to be. So I think it's an area that it's a good question in that it's an area that could be neglected. But if you don't get that right, what you'll end up doing is adding more time on at the end, because you've not put some fairly rudimentary checks in place to make sure that payments are going where they should.
Thanks, Andrew. And the last question I have, so if there are any last minute questions, do put them through on the chat facility now. But the last one for the moment is, in lower value whiplash claims, are we likely to see much impact on life cycles?
Yeah, that's quite a key topic. I think in the short term, probably, because we've got cases that are sat there. We've got the Supreme Court challenge off the back of the mixed injury tariff. So there's an argument on both sides that until these issues are determined, claims can sit. Now, if claims are sit, a bit like in the pandemic era, if claims are sat there, naturally they're not moving. So claims life cycles will potentially be impacted. So I think because of the proximity of the whiplash reforms and perhaps some of the uncertainty around where we all are, I think the answer is probably yes.
And I've just got another one through on the chat facility, Andrew. So that's, do you believe there is a disagreement amongst the insurance industry and claimant law firms in how cases should be valued? And has this resulted in claims that cannot progress?
From experience, now, I think I can give a slightly general answer and more direct answer. There are some firms who will either not value cases, or they will say that they're unable to value cases because they need to. Let's use an injury claim, for example. Everyone should have a good idea about what the case is worth. My view is that a lawyer on both sides, or the parties should be able to go away and value it. Now, the problem that you have is that it's very easy to say, I need a further report. I need another opinion here. I need to look at this in 6 months after this recommended treatment. I find that quite frustrating, and I'd imagine insurers do. Now, I don't think, in a perfect world, parties on both sides will always try and arrive at a resolution, because ultimately that's our job. But there are some that may not, and it goes back to the claimant behaviour point, and that's where you look for patterns around, why are cases taking longer to settle? Is it because they don't want them to settle, or is it because they are naturally by their nature complex? So I think generally, I don't think there is a wide disagreement. I think you will have sharp practice, and sharp practice can crop up on both sides.
Great, thanks, Andrew. And that's all the questions that have come through. So it just remains for me to say thanks so much, Andrew. That's really been really useful and fascinating, actually. And I think has given us a rare insight into the legal process surrounding claims. So thanks again. And thanks also to all of you for joining us. Please don't forget to provide your feedback, and do look out for forthcoming MGAA events. I hope you have a productive afternoon as always, and thanks again for joining us.